going over your resume, and I forget where the heck I was here, but
I think you asked me why I left Fierce, Kane, and Bloomberg was the last question I remember.
which,
In Northampton.
okay, yeah, and what was?
I realized I really missed public service and I wanted to be back working in the courthouse system. I also don't think that I particularly have the great, I'm the type of person who beats down doors for clients. And so at that point, I looked for an opportunity to get back into the court system and public service.
Okay. So you left public service from the DA's office the second time you went in to go to get out into private.
Yes.
You didn't like private.
I love aspects of it, but I definitely think that I thrive more in public service, and it's something that I really love, feeling that I can contribute to my community in that way.
You don't have a lot of trial experience.
I don't have a lot of reason trials. As an assistant district attorney, I tried probably estimated over 50 trials.
How come you didn't put them down in your filings?
I believe that's listed in my application, my JNC application, but I have had 50 plus trials. Most of those were bench, but I've had jury trials as well. I'd say about 14 jury trials at that time when I was at Fierce, Kane, and Bloomberg. I second chaired one of the partners on 3 murder trials. I did impanel a case in Superior Court. Unfortunately, the defendant in that case fled before we could actually have the trial, so I prepared that trial, but I wasn't able to complete it. We did impanel though. And I've done eviction trials in housing court as well.
Okay, I have. Yeah, wait a minute. Let me ask you this question. When you worked in the district attorney's office, who was, who taught you, or who was your mentor, or who?
Eileen Sears was my supervisor. The two Eileens, Eileen Sears and Eileen Leahy, were my supervisors at that time. So I learned under the two of them as supervisors. In that office at the time, Bill Bennett was the district attorney. So he routinely is one of the best hands-on bosses. Used to come down and sit in on trials and come into the courtroom as well.
Yeah, I know Bill. So on page 11 of your JNC application, it says list the 5 most significant trials, appeals, or transactions or other legal matters in which you have been involved in your career.
Yes.
And you cite Saldana versus the Registry of Motor Vehicles, and that was an appeal to the Superior Court to return a license?
To return someone's right to operate a motor vehicle in Massachusetts, yes.
Okay. And that wasn't a trial?
No, no, it was not.
Okay. And I've done those in the Superior Court. They take what, about a half hour?
About that.
Okay. The next case was Commonwealth versus Colaza.
Yes.
You second chaired that
Yes.
in the fall of 2016.
Yes.
Who was the trial lawyer?
It was Jeffrey Brown.
No, but who was the DA?
And this is, if I.
Were you in the DA's office then?
No, I was not. I was.
Oh, you were chairing it for the second.
I was with the defense.
You didn't put down the judge or the docket number?
I couldn't remember the docket number, and I said to myself, if I'd known I would ever be sitting here, I would have taken better note and putting those in a trial notebook. And
But when you went to fill this application out, did you think of going to the court and getting the docket number and the judge's name and filling this out?
I tried, but I obviously didn't succeed.
What do you mean you tried? I don't get that.
I-
I can go
well,
tomorrow,
I-
I can go tomorrow and get this in Springfield. All right?
Yes,
The next case is Commonwealth v., and you don't put the name of the case. Why did you put the name of the case?
I believe that, if that's the one, is that the motion to suppress case? I
Yeah.
don't believe I remembered. It was most significant to me because of what I learned from that case, but unfortunately, could not remember the name of the defendant. And that's why I left that blank.
It was a district court case?
It was a district court motion to suppress.
And the fifth case you put is adoption of an issue. Right?
Yes,
So those were the 5 most important cases that you had? Yeah, strike that. That's the 4th case. The 5th one was Commonwealth versus Bruno.
Yes.
2013, Judge Carey. Right?
I think that should be, that might be a misprint. I believe that was Judge Agostini. Was in that case.
It says Commonwealth versus Bruno.
Yes, BRUN.
Camden County Superior Court, Judge Richard J. Carey.
It must have been.
No
Judge Carey.
docket number, dates of involvement. October 2013, you second chaired the case.
Yes,
For the defense?
for the defense.
And how long did that case go?
That case was, I believe it was 2 days. That was a bench trial.
The next question, you were asked to list the 5 most recent cases that have gone to trial. For each provide names of the case, the docket numbers and everything else. You don't list any cases.
The last 5 years I have been
It
an
doesn't,
assistant.
well, it doesn't say 5 years. It says list your 5 most recent cases that have gone to trial. That means if your cases are 10 years ago, those are your most recent, you put them in.
I should have, and I anticipated that, my understanding of that question was that you'd be interested, that the council and the JNC would be interested in more recent trial work, that I have trials that would
Who
apply.
would tell you that?
No one said.
I mean, personally, I'm interested in seeing your trials you did. I think one of the greatest attributes for becoming a judge is experience.
And I have, you're right, and I should have put that. I have
You didn't
had,
list any, not one. In the
And the
50
truth is-
cases you did in the DA's office, you didn't put one case down.
and I have had 50 plus cases in the district, and while I was in the ADA.
Did
And I should-
anybody at the JNC pick up on this?
They didn't ask me that question, no, sir.
I mean, a couple things are concerning. One, that you didn't answer the question. And you didn't provide the answers to that question. You didn't answer it. You went on with about 6 or 7 paragraphs about other issues. Then it says list the 5 most recent matters that did not go to trial. You list the case with Agostini, again, the involvement with the license.
Yes.
Same one on the first 5.
Yes.
The next one you list is George Knowles versus Massachusetts Department of State Police.
Yes,
That was involving an car accident.
yes,
You were in the AG's office.
I was.
You were defending the Commonwealth.
Yes,
Again, no judge, no docket number. You know, to me, one thing, judges have to read a lot of stuff. And they've got to read it correctly, and they got to answer things correctly. This isn't just detail. This is to give people a chance, if they want to look up the case number and see what you did on it. You list in your application that you had 90% of your work has been criminal work?
Yeah.
What percentage of trials were jury and non-jury? You put 15% jury, 85% non-jury.
That's correct.
I mean, did you think at all that we would be interested in seeing those trials?
Yes.
That is like, Judge Hennessy, the former Supreme Judicial Court Chief Justice, wrote a book about good judges. And it's in his opinion, the most important attribute becoming on the bench is to have trial experience. We don't know whether you've had any, because you didn't give us any. Not one case here that you gave us is involving a serious criminal matter or even a non-serious one in the district court. You didn't even put pleas that you had.
And if I had, and I know, I can tell you that I have a notebook and I went back and looked at it, and I should have brought it with me with whether they were guilty or not guilty, but that important information that you're asking me, I didn't keep track of, and I would never make it up. I unfortunately never.
No, I'm not saying you made it up.
No, I'm not.
What I'm saying is you didn't answer the questions. And I'm surprised it comes to here before anybody's even asking you about it. You applied for a judgeship in 2017, 3 different judgeships?
There were 3 positions at the time that were vacant, district court judgeships, yes, sir.
Did you file an application for that?
I did,
Different one than this one?
yes.
And you were only a clerk for 1 year at that point?
Yes.
What made you think you were ready for a judgeship in 2017?
I believe that I had developed the requisite skills, that I had experience in both the civil arena as well as the criminal arena, and that I was ready at that point to take on what I believe to be a tremendous responsibility and one of the highest forms of public service, which is being an associate justice.
Some people apply for this position because it's got a great salary, great pension benefits, and a wonderful health plan.
Well, they probably don't sit as an assistant clerk magistrate in the Springfield District Court and see how incredibly hard our judges work. And I'm sure, and I see them with an overfull docket with 90 pre-trials and a full lockup, and giving people the same amount of energy and compassion at the beginning of the day, at the end of the day. So I think they work really hard.
I don't doubt that. I've been in Springfield Court a lot, and I don't doubt that. I've been in courthouses, every courthouse in the Commonwealth. I find judges and assistant clerks and probation officers do a great deal of work. My daughter's a probation officer. My other daughter's an assistant clerk in the Plymouth Superior Court. I know how hard they work. But at the time you applied for the 17 thing, you only had a year in the court.
That's correct.
My other pet peeve is, you're not the only one that does this. Question 53, list all books, articles, or other publications that you personally have authored, including the citations, dates of publications, and names of any co-authors. You remember what you answered?
None, not applicable.
I wish you had answered none.
What did I?
That's the answer. Yes or no, right?
Yes.
You put not applicable.
Yes.
Not applicable, why?
No, it's none.
It seems to be, nominees seem to do that. I've read one where there's like 10 not applicables. It's like, did you read the question? Yes or no? You owe $40,509 on a car loan.
I do.
What do you have, a Bentley?
I do not have a Bentley. I have a Mercedes, and it's not quite that high now, but yes.
Mercedes,
I do have a
wow.
Mercedes.
Must be good being an assistant clerk, huh? That's a high car loan, I gotta
It is
tell
a
you.
high car loan, I grant you that.
Wow.
Good thing I like it a lot.
Huh?
I said a good thing I like it a lot.
Uh, So you've been a lawyer for what, 16 years?
Yes, sir. About that.
You've only practiced though, about 10 or 11, right?
I think that's fair. I think it may be a little bit longer, but there was a period of time that I definitely took off where I wouldn't say I was practicing full time.
Let me just ask you a couple of questions here. What do you think of mandatory sentences?
I don't agree with them. I think that that judges need discretion based on the circumstances that they're being presented to make to craft an appropriate disposition, and I think that they hamper a judge's ability to do that.
So here's a question. You're sitting on the bench, and there's a mandatory sentence, and you know it's not a fair sentence. You know it's very unfair to that citizen standing there. You're going to impose it?
I have to impose the law, so if ultimately that's the requirement under the law, then as much as I'm uncomfortable with it, I don't think I have a choice otherwise.
Well, I disagree with you.
Okay.
There was a judge in the Superior Court in Worcester County who faced that dilemma with a 10-year minimum mandatory sentence. It was a woman, short little woman, a lot of courage. She said, I am not going to, this is an unfair sentence and I am not going to follow it. So she gave the individual, I think, 2.5 years or something. Of course, it was appealed and it was reversed, but she made her point. And you know what happened to her after that?
Nothing?
Nothing. She didn't get fired, so you won't get fired. Judge Harrington in the federal court refused to sentence people in criminal cases under the guidelines of the mandatory guidelines. But I'm not doing it. You didn't get fired. Just think if every judge did that with an unfair sentence, the legislature would probably change it. So I like judges that come here and that go out, be bold, don't be afraid to do things. No one's going to fire you. The best they can do is transfer you. You might sit in Greenfield or Pittsfield or Orange. It's a nice ride out there. You'll love it. Do you think we incarcerate in this Commonwealth more minorities because
Yes.
they're minorities?
I think that's true. I think that's.
Why
yes.
do you think that's true?
I believe that bears out in the study that was commissioned by Justice Gantz, that we incarcerate more minorities. I think the statistics are clear that that's the case.
Do you think there's racism in our court system?
I think that there is, yes, whether it's intentional or unintentional, I believe that it does exist in our court system, yes.
Have you known people that have been racist in your opinion?
I have seen recommendations made that seem to change based on race. Not often, but I think it's happened.
Do you think minorities get sentenced to higher sentences than non-minorities?
I think so. I think that also bears out in the study from Justice Gantz, that I think that study indicated that people of color, when the alleged crimes are equal to that of people who are not of color, that the charges start out more serious than those of their counterparts. And then even when they're amended down to the equal charges, that the sentence is usually more serious for people of color.
Well, how are you going to handle that in the court? The DA's office wants a higher sentence and you get the feeling it's because this person is a minority. How are you going to handle that?
I think partly is being aware, I think, of a potential,
Well, you are aware, but how are you going to handle it?
well, I
Are you
will,
going to give the higher sentence?
no, I will give the sentence that I believe is appropriate based on all the circumstances presented in front of me, not just, and consider all the circumstances that I have in front of me. So I won't impose that sentence simply because the Commonwealth is asking for it. No,
Are you going to be a Commonwealth judge?
no, I would not be.
You
a
know, us lawyers sit in courtrooms all the time. You know what we do when we're whispering to each other? We're talking about the judge.
Of course.
Like a ball player sitting in the dugout, they talk about the pitcher. But we talk about judges saying, hey, how's this person? You know, should we do this? Should we do that?
Of course,
So-
I think the benefit that I've had, honest, as being an assistant clerk is that I have, a part of my job as an assistant clerk is to be impartial. So I have that practice in small claims hearings, in show cause hearings, and all those sessions and being impartial. So I would not impose a sentence just simply because the Commonwealth asks me to impose it. I would hear from all sides and the information presented me to craft the disposition that I believe is appropriate for those circumstances.
Here's what I see. I see when I represent people from minority communities, of course, there's a big minority population in Springfield and Hoyle. And it struck me a few years back that when I look at the BOP of some individual, even if they're young, 20, 21 years old, they've had a lot of contact with police. Whereas I don't see that same thing if they're from some Weston or Wellesley or Long Meadow. So I think the interaction is greater because they are minorities. Therefore, they end up with more on their BOP than somebody from Long Meadow, a young kid from Long Meadow would face. So now they're before the court on another charge, and the judge looks and sees he has a record. So he gets sentenced higher than somebody who doesn't have a record. And to me, that's a form of racism.
I think that's a good point.
I was asking myself a question in the last year. So why do we all, DAs, lawyers, and judges, look at somebody's record? Can you tell me why we do that?
Well, I think it does, I mean, there's certain instances where I think the record does give a picture. I think you do have to consider whether or not a default is an appearance default, whether it's a default on payment and fines. I don't think those are equal. I think we look at them if it's a second offense to make sure that the charging is appropriate. So I think there are various reasons that we do look at a person's record.
I've been hearing since I was a kid that in this country, once you pay your price to society, it's over. But not in our court system. It keeps getting rehashed and rehashed, right? Progressive discipline. I think the court system uses that now for employees. So do you think going to jail has worked generally over, say, the last 100 years? You think it's worked as to what it was designed to do?
I guess the question is, what do we think it was designed to do? If it was designed to punish, maybe. If it was designed to rehabilitate, probably not. I mean, I think it depends on what it was designed to do. Was it designed to keep people as a public safety? I think sometimes we do have to incarcerate people as an issue of public safety. So I think it depends.
So you're sitting on a bench and a probation officer says, Johnny Smith is here, he violated his probation. He tested positive on the urine. I want him to go to jail. You're gonna send him to jail?
On just that hypothetical? No.
6 months later, PO comes back in and says, Johnny Jones flunked another urine. I want him to go to jail. He's a heroin addict, flunked the urine. I want him to go to jail. What's Judge Williams gonna do now?
Again, probably not. It's been 6 months. It sounds like It's a relapse. It sounds like unless it's been brought for a warrant or something else, it sounds like he's been
No, that's the only
on
issue.
board, then no, I would not.
All right. What about the third time?
I need to know a little bit more. Probably not, but I don't know if there are any other issues that
No,
would
that's
warrant
the
it.
only issue. There's no other issue. He's peeing into a cup. He tested positive, period. He's got a heroin addiction. Do you think jail is appropriate for people with an addiction?
No,
Why are we, the royal we, why are we putting people in jail for that?
but I think when it intersects with a crime,
No, just this. Leave it to this just.
okay.
I've been in courts where those happens. Why? It's not working. We don't put people in jail if they relapse from smoking. Right?
We don't know.
This is a medical condition. Everybody that sat there, everybody that comes in here says that.
It is. I agree.
What other medical conditions do we treat with jail? I don't know. Then used to be a crime, to be drunk in the Commonwealth. It was chapter 272, 48 or something. I forget from my days on the police force. But you could arrest somebody just for being drunk. And then somebody said, that's not good. They're addicted to alcohol. They shouldn't be charged with a crime. Not so with other drugs. Do you think somebody on probation gets supervised?
I think it depends on the case and the conditions that are imposed. So I think it depends.
I got to tell you, I don't see a lot of supervision going on. I don't see a lot of morale in probation in the Commonwealth. In fact, I see very little morale. And I had a case in Stoughton Court one day, and probation officer said, I'm going to ask for jail time because your guy flunked the urine test. I said, okay. So we called the case. First case I got called. The judge said, you're going to admit? And I said, no, Judge, I'd like probation officer to get on the stand. He got on the stand, the file was about this thick. The guy had paid his probation supervision fee up. It was a 4-year probation. Paid it right up to the end. It was only a year and a half. He said to the probation officer, can you open your file and tell me the supervision you've given this man? He didn't open the file. He said, I haven't given him any. He said, well, you're going to give him back his money? Paid for supervision. I said, he said periods of being clean, 3 or 4 months. Open your file. Did you call him and tell him he was doing a good job? No. Did you ever encourage him by saying, if I can help you, please just let me know? No. And in addition to that, I said, my client has been here 4 times in the last 3 weeks on your order. And because of it, he's been laid off from his job. Here's the letter from his employer. So I said, you've got your job. He said, yeah. He doesn't, because you told him to come in here 3 times and you weren't available. And now you want to violate him and put him in jail. Well, how are you going to be on fees and fines?
I think there are too many of them. I don't. I think that a lot of times people are, or sometimes that's the only thing keeping probation open. So I wouldn't incarcerate somebody just for fines, or just keep a case open and extend it just for the payment of fines.
I'm talking about when you impose a sentence.
Mhm.
The lawyer says to you, I'd ask you to waive fees and fines. What are you going to do?
I review the financial statement and determine if it's appropriate. If someone is indigent, obviously, you shouldn't be imposing fines that will set someone up for failure.
You're not going to be like some judges I know that actually think they're working for the Department of Revenue rather than being a judge.
No, sir.
Most people that come into Springfield District Court don't have a lot of money.
Mhm.
Paying a fee or a fine is a lot to them.
It
Not
is.
to us sometimes, but to them, it's a big deal.
That's true.
I think it odd that we chase around people for not paying $100 or $50, and we get warrants, and we have to have the police bring them in, and they go before a judge. Talk about a waste of time and effort. So I'd ask you to think about waiving fees and fines. These are the people in the Commonwealth that are paying for all of us in these government jobs we have. Have you ever, you know about dangerousness hearings?
Yes.
You think the prosecutors use those too much?
Sometimes.
Yeah, I agree. Sometimes, yeah. It seems to be getting to be more and more now.
We are definitely seeing an increase in requests for dangerousness hearings.
So I hope you're not going to be a judge that just rubber stamps all these dangerousness hearings, puts people in jail.
No, absolutely not. I would listen to the evidence and make my determination based on what I've.
What do you think of school zone violations of drug cases?
I remember having those as a prosecutor. We had way too many of them. I agree with the change in the law. We don't actually, in Springfield, we don't see a lot of those anymore. I think that in Springfield, you couldn't go anywhere without being near a school. So I think there were entirely too many of those cases.
So you said to me back a few minutes ago, like, what could I do about a certain topic? In Boston, in the BMC, the school zone, there's no place in Boston you cannot be in the school zone. And I've had many cases where the police have enticed the guy into a school zone to sell and buy, and then arrest him for the school zone. But in Boston, there were a significant amount of judges that would refuse to input the school zone. The judges would say to the defense lawyer, try the case. And they would find the guy not guilty of that because it was so unfair. So there are things you can do as a judge to get around unfair statutes. Okay. Tell me what you think the term judge shopping means.
I think it means being aware of what judge is sitting and when, and attempting to get your case in front of that judge that you think is going to be favorable to your position and to your case.
What do you think of that?
I think any judge, any attorney who is in any court, it does it and should do it. I think it's good legal practice to try and do the best you can for your client. It's advocating for your client.
So if I come out to Springfield and Judge Williams sitting, and I say to an assistant clerk or the clerk, hey, can you get me before another judge, you're not going to be offended?
I won't be offended, as I don't know if the assistant clerk would do it, but I wouldn't be offended if someone asked me.
No. So I think of that term.
Mhm.
I don't think it really exists. I'll tell you why. Yesterday, I got a trial date and on the Zoom.
Mhm.
It's in December. I have no idea who's sitting in that particular court in December.
Right.
When I get there for trial, it's a jury waive trial, but if I get there and it's a judge who I know has never said not guilty in his entire life, I'm not going to jury waive it, right?
Right.
So when they say, judge shopping, I don't know who I'm getting when I show up. And even if I see the schedule, the 30-day schedule, and Judge Williams is sitting on this day, and I go, she's the one I want to get.
Mhm.
When I show up that day, you may not be in the trial session.
That's right.
In fact, you may be on vacation in Bermuda or somewhere.
Exactly.
So I think the term judge shopping is misused in that regard. What do you think about, it's on for jury trial and the defense lawyer jury waives? You going to allow them to do that?
Yes.
Okay. What if somebody has signed a waiver of rights before the trial,
Mhm.
and they get to your session, and a particular lawyer says, well, I think I better have a jury. He says, I want to have a jury now. Are you going to say, no, you've already signed that, so you lose the right to a jury?
No, I would allow them to go jury.
There are some cases where that is not done. I was in the BMC the other day, and the DA said to me, you're here for trial. I said, yeah. He said, well, did you sign a jury waiver? I said, no. I don't know who I'm getting. I didn't sign anything. Oh, he said, we're having lawyers sign. I said, the DA's office is having lawyers sign jury waivers? I said, no. And the judge, who was a pretty good judge, asked me about it, and I said, well, Judge, 5 Supreme Judicial Court judges in this Commonwealth sat in the seat you're in right now and said it would be ineffective assistance of counsel and malpractice for any lawyer to waive a defendant's rights before they knew what judge was sitting on their case. They said that from your chair. So I say to judges, I don't want to commit malpractice. You know what an Alford plea is?
I do, yes.
What is it?
An admission to sufficient facts.
What else?
Sufficient facts that if the Commonwealth's case as presented, I would find the defendant guilty. Be enough to find the defendant guilty.
Okay, but you know the difference between a regular plea and an Alford plea?
Usually, my understanding with an Alford plea, someone doesn't recall the events or has no recollection of it, so is admitting that.
Well, you're close,
Okay, tell me then.
but you're not 100%.
Okay, I'm ready.
Alford plea comes from Alford versus North Carolina's case. So when you do a plea, you're the clerk, you're there, and the judge does the plea.
Yes.
And then he says, I want you to listen to what the DA has to say, and they read the facts of a case.
Right.
And then judges turn to the defendant and say, is that basically what happened?
Right.
And they say yes. Well, an Alford plea, it's exactly the same, except that question isn't asked of the defendant. Do you agree with that, or is that what happened, or did you do that? That question isn't answered. So the same sentence is imposed, same probation, whatever it is, fees, fines, whatever, but that question isn't asked. And did you ever see any Alford pleas?
Yes, I've seen some of those.
Would you be a judge that would allow them in certain cases?
Yes.
They're beneficial in this sense. Sometimes people get charged with a crime, first offense, and they're facing jail time if they try it and lose. So they wish not to run that risk, but they maintain that they're innocent. And the studies say about 15 to 20% of people that get found guilty are innocent or didn't do the crime. Jurors get it wrong that much time. But the other thing is, unlike the probate law, which many years ago, before you were around, one of the only ways to get divorced was to claim cruel and abusive treatment by your spouse. Usually it was a wife saying cruel and abusive, and the judge would ask her questions. How's your health before you got married? Good. And how is it now? It's narrow. It's terrible. How's your anxiety level? Oh, it's worse now than ever because I've been with him. And then you go through this whole colloquy. And probably 90% of the cases, it was all made up. But it was the only way to get divorced without claiming adultery or imprisonment or alcoholism. So the judge knew the person was probably committing perjury. The lawyers knew they were committing perjury. And the legislature finally said, well, why do we make people commit perjury to get divorced? So they instituted no fault. So you don't have to say anything anymore. But in our criminal system, if you are innocent of the crime you're charged with, you didn't commit it, and it's a serious crime, you face a tough choice. Going to trial, losing, and going to jail. or making an admission to something you didn't do so you don't go to jail. So sometimes an Alford plea is a good way to resolve the case. So the client says, I'm not going to say I did it. Okay, you don't have to. We'll do an Alford plea. It's agreed that you'll get probation and you won't face a jail time. So to me, it helps get rid of a case, and you're getting the same penalty. It's not going to matter. So anyway, that's the deal on that. So I hear a lot from people sitting where you're sitting that they're going to follow the law. Did you ever hear that?
I do, yeah.
What do you think of that?
Well, I think depending on,
As a judge, I mean.
As a judge is going to follow the law.
Yeah.
Well, I think you have to follow the law.
I don't know what that means. What does it mean?
I think it means, it's a very broad statement, but I think to me, it means that I am going to ensure that I am making decisions that fall within the case law, the applicable case law, making decisions on motions, things like that, that it involves the applicable case law, that falls within the statutes, that I'm not just going to ignore the law, ignore case law and statute that applies to a case.
You ever been to the appeals court?
No.
Okay, well, there's 3 judges that sit on a panel. They listen to the evidence. Sometimes it's 2 judges finding one way, 1 judge the other, or the Supreme Judicial Court. Maybe 4 judges and 3 against, right? Which ones aren't following the law then?
Well, I agree with you. It depends. It could be their interpretation of the law.
Well, isn't that what judges do every day?
Exactly, interpreting the law and interpreting.
And you could have a case in one session where a judge interprets the law this way and go right next door and have the same case and a judge has a different interpretation.
Absolutely.
So when they come here and say, well, I'm going to follow the law, I say, you're going to interpret the law.
That's right.
If you were following the law and every judge followed the law, there'd be no appeals courts. We wouldn't need them, right?
Right.
So anyway, okay, I'm done. I appreciate you putting up with me here, and again, you've had good people speaking on your behalf in a letter from Bobby Santinello. Very important to me.
Thank you so much.
Joe Franco told me that he's had nothing but good experiences with you.
I appreciate that.
So I appreciate it, but thank you so much.
Thank you for your time.
All right, thank you. Anyone else have questions?
Are you calling on me?
Counselor Devaney?
Thank you. Hi, nice
Hi.
to see you again.
Nice to see you as
It was
well.
really a pleasure, and where this was so fast, it's amazing. You got your family and you got your people to speak for you. You're amazing.
Thank you so much.
And I enjoyed meeting your mother and you. That was a great thing. I apologize for that, how you had to rush, because on the application, it asks you to present your application within, within, I don't know, 6 days or something, isn't it? And you were told one day, and it was even, I don't think it was even maybe 6 days you had, but it was anyway, it wasn't sufficient, but you did it. And in that time, we even had a meet on a Sunday because this came up so fast, which I think we should go by what it says, because, you're supposed to give all your information within so many days, and it's not even within that time. But so thank you. I appreciate that. Now tell me, you went before the JNC. How many lawyers were there?
I think it was over Zoom, and it was very hard to keep track of, but I think I had about 8 or 9.
9.
I think it was 9.
It was 21. With this, with Mr. Dacier, he does it differently, and it's not pleasing to me, because I think that all of the people who are voting for the nominee, all those attorneys that are appointed by the governor, should be at that hearing asking you questions. And how many did you say were there?
I think it was 9.
Yeah,
And you
9.
Said it was
9.
Zoom, so.
So,
so-
the majority are voting for someone they never met. That's not the way it should be. That's not your problem. I keep saying it, but it doesn't go anywhere. And I've been here a while and it wasn't done this way, So anyway, but it was a pleasure meeting you and your mother. It was great. First of all, congratulations.
Thank you so much.
The thing is, well, my colleague has asked a lot of questions. I was crossing them out as he asked. One of the things that, that we see that is so different than someone 40 years ago serving is the drug problem. And it's real, and it's not going away. So you have been involved in that, in drug cases, and you've made recommendations. See, my thing is that, we don't have the facilities. And, what do we got? We got something in Framingham, I think, and there's only a few. And it doesn't meet the needs of people. And in the last 2 years, I've had 2 friends, each had a son that overdosed on heroin and died. So I know personally what it does. So, but the other thing is, you have represented people who have a drug problem too.
I would say I only prosecuted drug cases. When I was in private practice, the defense cases I had did not involve the allegation of.
Yeah. Well, we don't have pads around here anymore, which is, to me, is a disgrace. I keep asking for them. And we had a pad maybe, oh gosh, I don't know, 10, 11 years ago. And it broke my heart. This goes back to a young man who was in high school. He was 17. And on his way to school, an older friend stopped him and said, "Would you sell these bags of marijuana?" And so, he's a kid. He took them. And he said, "They're $25 a bag." So he went into the school and he sold 1 bag. And when he asked another boy, that boy went to the principal and told on him. So they found them in the locker. So, so he did time and he lost out on the best years of his life, proms and maybe a scholarship to go to college, sports, all of that. And so when he got out, fortunately, he got a job as a custodian. So during the time he was out, he got cancer, he lost a leg, he's gone through a lot of physical things. And I think how sad that there couldn't have been any leeway for this young man, never had been involved in any kind of things like this. And he wanted to do a favor for an older friend, and that's what it was. He didn't know. And so, that was really heart-wrenching, because the other thing is the school is closed. And so I don't know what he's going out to get. And, he has a record. So, those are the things I look at, and I just say, there's got to be, some intervention. There's got to be more teaching about drugs so that a young fella doesn't have to have a full sentence that he has to serve. But having said that, now, so the thing is, you are right now, you are are you a clerk magistrate?
assistant
Okay,
clerk
and you were
magistrate.
assistant?
I am an
You are
assistant.
assistant.
Yes, I'm an assistant
Okay,
clerk magistrate.
so in your courthouse, how many clerk magistrates do they have?
That's a good question. We're down a few, and my boss is watching, so I better get this right. So I think we're down. I think we have 7. at the
Yeah.
moment.
And so, yeah, and so clerk magistrates, how many?
Assistant clerk. We only have 1 clerk magistrate, and that's
Wow.
Mr. Gay.
Yeah.
And we have assistant.
Is that the norm for, a courthouse that big, or what?
I can tell you that we are down, and based on the work that we're doing, I think our assistant clerks are doing superhuman work with the amount of cases that we have coming through the Springfield District Court.
Um, So you were asked in your questionnaire to list the things that you thought were important in court, and a there was a couple of them that you really didn't direct your answer to. Do you remember that
I don't, but I
question?
think you're right.
Oh, okay. Well, I'll let that go. So, okay, so how many criminal cases have you had?
I would say that I've had criminal cases about over 50. Excuse me, criminal cases. I handled a caseload as a prosecutor of about 300 cases. So I
So,
can't count. how
so
many
you're
I've had.
involved in the trial from beginning to end?
It's a prosecutor started at arraignment, went to pretrial and trial. It was at my caseload at any given time was 300 cases. So countless. I can't tell you how many cases I've handled, but quite a
So-
few.
So has it increased? Has you changed your position?
I don't think, no, I don't handle, it depends on the session, so I don't have like a set caseload, but our average pretrial session is supposed to be 75 and usually borders up against 90, 95 cases. And arraignments, we probably, usually probably have, if you factor in walk-in on warrants and then summons and then just arraignments, you're probably looking at over 100 cases a day there. So it depends, but it depends on every session is a lot of cases.
I have to tell you, I'm disappointed in your answers because I like to really get into the cases and everything, and there really wasn't descriptions of the, the cases that you were involved. Do you see that?
Yes. you do.
Yeah, that, so that's some kind of, space in this for me to evaluate. I only know, I like to know the rest of the story, So anyway, so you have applied 3 times
I applied,
in all the same year, 2017. So tell me, do you think you were ready then?
I think I have gained, I think I'm more ready now. I think that having more experience as a person in life and experience as an assistant clerk in the different sessions has better prepared me. So I definitely feel more prepared now than I did when I applied then.
Right. So in those, so were you interviewed for those 3 positions?
I was interviewed, I applied once and there were 3 vacancies, but I hadn't interviewed yet.
Okay. So so what do you think is the biggest challenge now for you if you are a judge in our court system?
I think the challenge is balancing the administration of justice with doing the substantive work, meaning that, there's pressure to get cases moving, to finish the day, get the lockup empty. But you also have to give each person a fair opportunity to be heard to make sure that the case is appropriately addressed with attention, decency, respect, and compassion. So I think there's the tension just to make sure that you're not rushing through the day just to get the work done, but really making sure that people have the opportunity to be heard that they deserve.
With this, this problem that we're living through, and courts are closed, and it's, they're not doing all the work that they would normally do. Do you see that this workload is going to be addressed? Because I know in one of them, they have, I'm trying to think, they have something like 800 cases that haven't been, what's going to happen? I mean, how are they going to address this?
We're doing our, we're higher pay grade than me, but we're doing our best to address the backlog, but it definitely is a challenge. It's a challenge trying to address that backlog, getting more, and keeping people safe. We want to continue to keep the public safe and everything, but it is definitely a challenge. I think it will take a long time before we catch up.
Now, in your position, how are your responsibilities different than the position you held previously at the courthouse?
So as an assistant clerk magistrate, I'm impartial. I have administrative duties, so I keep the official docket for the court. I run the sessions where I need to run the sessions, make sure things are happening smoothly as best I can. I also have substantive duties, so I review criminal applications to make probable cause determinations. I review applications for search warrants. I preside over small claims sessions over the civil motor vehicle infraction sessions, the criminal show cause sessions. So that's a little different. So I'm not advocating for one position as a prosecutor. I was advocating for the position on behalf of the Commonwealth. And so and now in my position, I'm an impartial person in the court doing that work.
What is your proudest outcome of all the cases that you've seen?
I think that's a good question. I'm personally proud of my work on adoption of Anisha. I'm proud of that work because it was something I'd never done before, which was an appeal of the decision of DCF to terminate parental rights. And there was a very quick turnaround time. They asked for a volunteer. I volunteered. I'd never done an appellate case before. Wrote the brief, and it was a novel issue of jurisdiction, which I was able to do in a short period of time. I'm really proud of that work personally. But I would say some of the cases I'm most proud of as a prosecutor cases, there are two bullying cases that really come to mind. And one, in all honesty, I null prossed, and I'm proud of that work because a lot of times I think lawyers get so consumed with a win that they forget that these cases involved individuals. And this was a case where a young woman was being bullied, and because she allegedly had some contact with one of the girl's boyfriends. And so they were beating her up, they were harassing at school. And my case involved an assault and battery with a dangerous weapon, and it was a very strong case, and the case was ready to go to trial. And in preparing the case, I learned that there was a Superior Court case with the same victim. It was a mayhem case. And one of the girls in the group had disfigured her by cutting her face. And that case ultimately ended up in a jail sentence for that individual. And when I called the Superior Court prosecutor to talk about my case, she said to me, I think you should consider null prossing the case. She said, I'm not telling you what to do, but I think you might want to consider null prossing the case. And it really surprised me. And I said, well, why do you think that? She said, well, I will tell you that this case upstairs has been a nightmare because the defendant has been dragging the case out as long as possible just to make this girl's life miserable. And whatever win you get in district court is going to pale in comparison to what she's going through. It really frames for me what's important. And so ultimately, I null pross that case because it's, remembering what the cases are about and about people.
Well, I was very impressed with your personal life and your dad, and he and how he wanted. Well, why don't you tell a story instead of me? I was very impressed with it.
My dad is, he grew up he was born in 1943 in New Fall, Alabama, a child of the South, and little boys with his race didn't become engineers, which is what he wanted to be. And I'm really proud that he didn't let anything stop him. He was committed to his goals and worked wherever he could. He worked in the Navy, worked on the auto line, knowing that one day he would meet his goal. And so he was the first in his family to attend and complete college, and became an engineer. And he worked for Digital, and he worked for Quantum Corporation, and he was a world-renowned resource in this profession. And I'm really proud of his example. And he was also, one of the things he taught me was that the truth is usually somewhere in the middle. So he was obsessed with Napoleon and used to read biographies, but he always makes sure to read 2 or 3 at a time because he felt like the truth was somewhere in the middle, that everyone has kind of a little bit of bias. But I'm really proud of him and obviously miss him every day.
Well, he wasn't told to, to go that road, was he?
No,
Was he
not.
told?
To become, he said he could be a cook or a janitor.
Right.
Yeah.
Well, who I think of? I think of Justice Island. And when he was in school, the teacher told him that you'll make a great mechanic. One of the greatest justice we've had in Massachusetts. So God bless your dad. That is something. And I was very impressed with that. So now in your experience, out of all the positions you've had, what position do you think has given you the best experience to be a judge?
Honestly, I think my work as an assistant clerk magistrate has prepared me. I think that everything, I have to, I have to say that every job and I've had it to this point has gotten to me here. So my trial experience at the district attorney's office is invaluable. What I learned there, getting up on my feet, trying a case at a moment's notice, I don't know if I can even separate them. I will say that as an assistant clerk in the Springfield District Court, you know who you are. When everything falls apart, you know what your temperament is, you know how you treat people, you know how to adapt to any situation. So I think that as an assistant clerk, the skills of being able to manage everything that happens in a courtroom and to be able to think outside of the box and be innovative, that has come from that position. But everything that I've had, every step I've made in my career has been important to get me to this point.
Well, I was impressed in your, reading about the adoption of Anisha, and thank God that had a happy ending. So you can tell us about that. And I was just wondering what happened to the other siblings. So why don't you?
Well, I don't know what happened to the other siblings because the mother in that case had lost previous children, and because her prior children had been, her parental rights had been terminated, and children had died in her custody previously. So I was aware of that information, and so
Because give the reason.
they were allegedly she was drug addicted, and the children were also drug addicted. But in this case, the child was born in the Commonwealth, and she had taken the child to, I believe, New Hampshire, and then Texas, and then had made arrangements for a family friend to adopt the child in the Caribbean. So the judge in that case in Massachusetts ultimately terminated parental rights, and the argument was that he didn't have jurisdiction to do so, and that number one, that the right shouldn't have been terminated, and that he didn't have jurisdiction.
No, that was a beautiful story. I thought about the siblings, but we don't know, right, what happened. So, what do you think for you personally is going to be the biggest challenge in this position?
I think, there's definitely a shift from being an assistant clerk to being a judge. You're making much tougher decisions. You have to consider that you're affecting lives and families and communities. And so I think that's an awesome responsibility.
When you look back at the cases you've had, what is the most that you look back and you're just so proud of that outcome? Is there one that stands out?
Proud of all my cases, honestly. Even the ones I didn't win. I'm proud of all of the cases because I learned something from every one of them. I'm proud of, I had a bullying case where a young man was just he was walking around a track, and someone just sucker punched him and ended up breaking the orbital bone in his face, and was able to give him some peace of mind in that case. So but every case that I've had are really important to me, even the ones where, I lost, and sometimes I should have lost, so those all, mean a great deal to me.
Right. Well, my colleague has asked a lot of questions that I asked. I kept crossing them out as he asked them, but in more that he asked. But no, I was very impressed with you, and I'm just wondering, what do you think is going to be the biggest challenge now, where there all these cases are, piling up? How are we going to, get them through and do the right thing and give it time?
No, I think that you've identified the biggest challenge is trying to get that backlog of cases seen. I think so.
Well, I have to tell you, it was a pleasure meeting you and your mom. It was great. And to take a Sunday to do that because it was so rushed, and I apologize for that. I had nothing to do with it, but it was a pleasure. So what do you think for you is going to be the biggest learning curve that you're going to go through to be a judge with your experience?
I think that although I've had civil experience, I'd like to, I think that I sit more in criminal sessions. So I think that I'm sure I have a lot to learn.
And I'm very pleased about your contributions. none. So that means a lot to me because you're coming on your own and on your own merits. And this is how I wish they all were, because you should come on your own merits, not buying it. So I thank you and for all your time. Sunday, it was really a pleasure to meet you and your mom. And I wish you all good luck and thank you all for coming. This was great that you had this many people. Thank you.
Thank you.
Very much.
Thank you very much. I believe all the counselors have asked all the questions that they want. I just have about 2 hours worth of questions, Danielle.
I'm ready.
Okay. Where are you going to take these poor people to lunch? They've been sitting here all day.
I think they have, I have the pescatarian in the family, I think, wants some fish. So we'll go to, I think we're going to go to Center Square.
Oh, there you go. Is your mom, would your mom answer a question for me?
Yes.
Okay. You can,
Yes, Councillor Hurley.
how proud are you of your daughter?
I am very, very proud of her. I know that if her dad was here, I know that he also would be proud and that he is just rejoicing. And she has worked hard and she's a woman of substance and integrity, and we are proud of her and love her. And thank you for all the work and all the hard work that you all have done and the support.
Thank you. So I really don't have any questions. As I said before, Danielle, Judge Payne has been your biggest cheerleader for a long time. And when you applied back in 17, basically you were just too young. But I think that the time that you've had has allowed you to grow more, to appreciate more, and to learn more. And being a judge is a learning process too. You'll have a mentor judge. You'll be able to rely on Survival Guide and a lot of the different books and what have you. It's just been a long journey for you, but you're going to continue to succeed. Your grace and cool under pressure has been tested time and time again, being a clerk in the Springfield District Court. I can recall days when I had 120 pretrial conferences to go through in courtroom 2. So you'll do a great job. My advice is get a robe, because from my count, you're going to get voted in next week. So congratulations, and it was a pleasure to meet you, Mrs. Williams, and thank you for being here. This hearing is now adjourned. Thank you.
Thank you very much.